So welcome to Constitution Day. I'm Jennifer Denbo, professor in political science. I would first like to thank Terry Krasinski for making this event happen and doing all of the important legwork. The theme of this year's Constitution Day is health law and the Constitution. We chose that theme in part because the political science department is launching a new minor in health law and policy. So the idea of the minor is to introduce students to the public healthcare system with a special emphasis on law and the politics that drives law. So I have their handouts over there for students who might be interested in that minor. It'd be really a great choice if you're interested in a career in a health law or policy kind of organization. We also have pocket constitutions over there, so feel free to help yourselves. You can carry them around with you at all times. Which brings me to the reason we're here today, which is Constitution Day. So in 2004, Congress decided that all educational institutions that receive federal funding need to provide educational programming on the Constitution. And this programming coincides with the signing of the Constitution. And so today we're happy to recognize Constitution Day and celebrate the Constitution here at UNE. We have a guest speaker from the University of Maine Law School, Professor Christine Dovick is here. So I'm just going to say a little bit about her, and then keep in mind we'll have some time for question and answer at the end of her talk, so keep your questions in mind. We should have plenty of time to talk about her talk. So Professor Dovick is, as I said, professor of law at the University of Maine School of Law. Her research is in the field of health law, intellectual property, and internet law. She teaches a range of courses in intellectual property. She graduated with high honors from the University of Illinois College of Law. She also obtained her undergraduate degree there. She's published widely in a number of law review journals. We're very happy to have her here. Today, the topic of her presentation is a bad connection, deficiencies and protection from genetic discrimination and its negative impact on public health. So please join me in welcoming Professor Dovick.
Good afternoon. Thank you very much for that kind introduction. As Professor Denbo, and first of all, actually, I wanted to thank the University of New England for asking me to speak here today, and in particular, Professor Denbo. As Professor Denbo mentioned, my background for most of my legal and academic career has involved focusing on issues surrounding the control of information and the technology related thereto, in particular the internet. However, as a result of some personal experiences, which I'll talk about briefly in a moment, I've become increasingly interested in the way in which these issues interact with health law and policy. And this has included articles on clinical trial data and, most relevant for today's discussion, issues surrounding genetic information. So, a little bit of personal background. I'm from the Midwest, so I tend to, overshare at times, but we'll keep this part brief. In 2004, I was diagnosed for the first time with breast cancer. I'm fine now. And at the time, my oncologist recommended to me that I have some genetic testing done to determine whether or not I was a carrier of one or both of the two known genetic mutations, actually one or the other. And you may have heard about these. They're called BRCA1 and BRCA2. And if you are a carrier of BRCA1 or BRCA2, it puts you at a highly increased risk for not only breast cancer, a potential recurrence of breast cancer, or a new diagnosis of it, as well as ovarian cancer. So, as part of the informed consent process, the genetic counselor cautioned me that if I went ahead with this testing and my results were positive, it could affect my ability to obtain insurance and potentially impact my employment opportunities. And this was due to the fact that while I had some limited protection in the state of Maine, because at that time there was no federal law, and Maine was one of the few states that did provide some protection from genetic information discrimination. But if I moved out of the state of Maine at any point, there was this potential that I would no longer have that protection. Despite the warning, I went ahead with the testing anyway. In my case, I was fortunate that they came back negative, but I needed to obtain that testing and the results in order to help me make some very important treatment decisions that I had to make. However, I know of a number of women who ultimately decided at that time to forego testing because they were really concerned about how the information might potentially be used concerning their genetic status with regard to BRCA1 or BRCA2. All right, so apprehension over the potential for misuse of genetic information is not something entirely new. In fact, by the time the International Human Genome Project had officially begun in 1990, with the stated goal of fully identifying the genes and determining the sequence of human DNA, substantial concerns had already emerged on how such data might be utilized. And this is particularly true in the context of employment and insurance-related decisions. So consequently, in the mid-1990s, there was a flurry of activity with several bills being introduced in Congress in an attempt to alleviate the public's growing concern and worry. And this was due to the fact that research studies, as I had actually anecdotally become aware of, showed that patients were increasingly avoiding genetic testing and participating in related clinical trials because they were really worried about how those test results might potentially be used not only against themselves, but family members as well. And this was problematic from a public health standpoint on a number of accounts. First of all, this information from such tests, the information from such tests, can be exceptionally helpful in taking preventative measures to minimize the likelihood of the occurrence for some diseases in the first place. Additionally, at the onset of a disease, such data might be essential to making fully informed decisions, treatment decisions, and provide for the possibility of lessening the impact or the severity of the now present condition. Moreover, without patients willing to enroll in clinical trials, there was also concern that future medical advancements could be potentially impeded. So, almost 2 decades after the first attempt to pass some sort of a genetic information non-discrimination legislation, the Genetic Information Non-Discrimination Act, otherwise known as GINA, was signed into law in May of 2008. GINA's proponents often characterize this as a new form of civil rights protection. For example, Senator Ted Kennedy referred to GINA as, quote, the first major civil rights bill of the new century, holding discrimination based on a person's genetic identity just as unacceptable as discrimination on the basis of race or religion. However, GINA was significant and is significantly different from the other major civil rights acts that came before it in a number of ways. First, while earlier anti-discrimination legislation, such as Title VII of the Civil Rights Act of 1964, was passed under Congress's authority granted by the Commerce Clause in Article 1, as well as the Equal Protection Clause of the 14th Amendment, in order to address discrimination that was already occurring, GINA is essentially preemptive in nature. This is not to suggest that there was no evidence of genetic information discrimination prior to its passage, but compared to the extensive history of discrimination that was the impetus for other anti-discrimination acts, even its supporters acknowledged that there was comparatively very little evidence of discrimination occurring on the basis of genetic information. Nonetheless, proponents of GINA argued that this was really a unique opportunity to anticipate a form of discrimination that would likely pose a significant threat in the future, as well as deal with some of those issues that I already mentioned, the fear and the impacts that it had over such potential discrimination that was already occurring with regard to public health and innovation in the sciences as a result of clinical trials. Even so, some scholars have suggested that this preemptive aspect of GINA arguably even calls into question Congress's constitutional authority to pass this anti-discrimination legislation without an existing history of discrimination. Second, one of the other fundamental ways in which GINA is quite different from prior, from prior civil rights legislation is the fact that, similar to other earlier acts, while it prevents or prohibits the use of genetic information in connection with employment-related decisions, what makes it very unique is the fact that it also prescribes even the acquisition of that genetic information in the first place. The original legislation, when the act was passed back in 2008, had numerous serious deficiencies in it, in part due to a combination of factors. You had a number of pre-existing laws that needed to be dealt with, the interplay between them, and the inclusion of several broadly worded exceptions in the statute itself, and we'll talk about a couple of those in a moment. Further complicating matters was the complete absence, in some cases, of definitions altogether, or the lack of any sort of clear or meaningful definition for certain terms, in particular, of all things, genetic information. So partially in an attempt to alleviate some of the inadequacies of the Act, the Equal Employment Opportunity Commission, who was charged with creating regulations, proposed and then implemented regulations in 2012 related to genetic discrimination in the employment context. At first glance, it seemed as though these regulations really solved a lot of the problems with the original legislation. However, when you take a look at these new regulations, and you do so in light of the way in which advancements in technology have enhanced the way and the manner in which data is now gathered, stored, and used, as well as the increasing ease with which seemingly anonymous data is now, including medical information, can be linked to a particular individual. These serious deficiencies, again, become very apparent. Furthermore, these defects really pose a threat to the overall goal of GINA, and arguably need to be corrected in order to ensure that patients are not deterred from obtaining pertinent healthcare information that, out of fear of how such data might be later utilized. According to a 2011 study that was conducted by the Pew Research Center, it turns out approximately 80% of of internet users go online to obtain health-related information. Additionally, almost 20% utilize the internet in order to connect with other individuals facing similar health issues. But while consumers are acquiring essential medical information, finding necessary or much needed support, they risk providing advertisers, marketers, data aggregators, and even employers with a host of sensitive information on the internet users themselves. And this is due to the pervasive use of extremely invasive technology that can monitor and chronicle internet users' online activities even without their knowledge. And these electronic tools can provide instantaneous information on exactly where a particular internet user is in terms of what page they're on, including where they're directing their mouse on the page and the keystrokes that they might be entering. This information can then be almost simultaneously cross-referenced with other available information to provide additional data, often including the user's age, zip code, gender, income, and even health-related issues. The scope and the breadth of such covert data gathering that can potentially provide information on one's medical related concerns and conditions is nothing short of astonishing. For example, one investigative report found that pharmaceutical companies, and I'm just quote this, are using stealth marketing tactics that include eavesdropping on patients' discussions on social networks and tracking patients' digital footprints online to target them for advertising. Additionally, another investigation revealed that other entities such as search engines, advertising networks, and online social networks, quote, harvest online conversations and collect personal details from various internet sites, including resume sites and online forums where people might discuss their lives, unquote. So this enormous amount of data is then used to build detailed profiles that, according to the Federal Trade Commission, are oftentimes, as they stated, quote, broad in scope and large in scale, end quote, and may include sensitive information, including personal medical data. Such data gathering has become exceptionally big business and is only expected to continue growing. So, for example, spending on information from online sources was approximately $410 million in 2009, and approximately $840 million in 2012, and similar increases in expenditures are anticipated in the future. Now, information gathering companies have traditionally argued that these actions, or their actions of gathering this data, are not an invasion of privacy, because the individual pieces of information that they are obtaining are frequently, at least according to them, are not in and of themselves personally identifying. However, this line of reasoning is becoming increasingly unpersuasive in light of the fact that there is a growing ease with which seemingly disparate pieces of information of seemingly anonymous, consisting of seemingly anonymous consumer data from multiple sources can be linked to a specific individual at very little cost. So, for example, some computer researchers have shown that by only using 3 pieces of information that internet users commonly divulge when you, for example, sign up at a website to get access to the site, that are your zip code, your birthday, and your gender, that the vast majority of Americans can be identified by name and address. Additionally, another case in point, AOL,
Can you say those 3 pieces of information again?
Yes, it's gender, zip code, and birth date.
Okay.
And if you take those 3 things, the vast majority of individuals can be identified and linked to an address. All right, so another case involves AOL, which is not as popular as it used to be, but nonetheless they had this huge amount of data on searches that users of their search engine that they had compiled. And they decided that they were going to release this material, and it consisted of 20 million search queries that they thought might help research. So before they released this, they anonymized, at least that's what they claim, that the data was completely anonymized. However, a number of New York Times investigative reporters were able to show that at least part of this information could be re-identified without much difficulty. So the article described the way in which these reporters went about linking various queries, including, I'll give you one example, the queries that were landscapers in Lilburn, Georgia, several people with the last name Arnold, and homes sold in Shadow Lake subdivision, Gwinnett County, Georgia. They were able to link all of these to this woman here, who is Thelma Arnold. She's 62 years old and lives in Georgia. She confirmed to the reporters that these, in fact, were her searches, and they included a host of others, including 60 single men and dog that urinates on everything. Slightly embarrassing, but even more concerning, is the fact that her searches, like the more than approximately 500,000 other users included in the AOL database, appear to reveal the concerns, interests, curiosities, and potentially medical conditions of the internet users and each individual. The other problem is they can also be misleading. For example, in Ms. Arnold's case, her quest for information online included running searches, or I should say, her quest for information seemed to indicate that she might be suffering from a whole host of maladies. Wide range of possible physical and mental ailments, because her search history also contained queries on hand tremors, nicotine effects on the body, dry mouth, and bipolar. However, such a conclusion actually would be at least seemingly inaccurate, because Ms. Arnold admitted in an interview that she, quote, routinely researched medical conditions for her friends to assuage their anxieties. And for example, she had had a whole bunch of inquiries on nicotine. She herself was not a smoker, but she said, quote, I have a friend who needs to quit and I want to help her do it. All right, so with this technological background in mind, I want to turn to GINA's provisions and then examine its various deficiencies in more detail. I'm going to look at 2 in particular, just because of time, and focus in on those. Before I do, it's worth mentioning that GINA consists of 2 main titles. Title I provides for, or prohibits genetic information discrimination in the context of group health plans. The regulations for Title I still have not been finalized. They remain in interim status. Title II prescribes not only the use of genetic information in connection with employment-related decisions, but the mere acquisition of genetic information in the first place is prohibited in most circumstances. As a result of the EEOC regulations that were implemented in 2012, genetic information is now defined in a less circular way, and it states that genetic information consists of information from an individual. That should be an individual's genetic test, the genetic test of family members, and family medical history. It also includes information about an individual's or family member's request for or receipt of genetic services. This means, for example, that if there is, let's say, a high incidence of breast cancer in your family, but this data actually would fall within this very broad definition of genetic information, even if you yourself have never been diagnosed with breast cancer or never had any testing done to determine whether or not you were a carrier of one of the 2 known genetic mutations for breast cancer. The regulations also provide that an employer may not request, require, or purchase genetic information of an individual or family member of the individual. The rationale, again, for including a ban on not just utilizing genetic information, but also the act of acquiring genetic information is that employment discrimination cases are notoriously difficult to prove. And in fact, employees are frequently ignorant that discrimination has even taken place. Consequently, in an attempt to even to prevent discrimination from possibly even occurring, GINA prohibits access to genetic information that may be the basis upon which discriminatory action might potentially take place. The regulations further specify that request includes conducting an internet search on an individual in a way that is likely to result in a covered entity obtaining genetic information. At first glance, these updated and seemingly expanded definitions appear to give considerably more protection to employees. Unfortunately, a number of exceptions in the Act appear to swallow up most or much of the potential safeguards that were wrought by the latest changes via these regulations. This is particularly so when it's assessed concurrently with the advancements in electronic data gathering and aggregation that we talked a little bit about a moment ago. So we'll take a look at one of the exceptions. The general prohibition against acquiring genetic information does not apply according to the Act and regulations, where someone acquires genetic information from documents that are commercially and publicly available. And so this is the commercially and publicly available information exception. And this safe harbor, so to speak, does not exist when the employer sought access to these commercially and publicly available materials with the intent of obtaining genetic information. Therefore, under the Act with the regulations as currently drafted, if an employer, let's say, conducted some sort of a pre-employment check where they got on the internet well, I should say, if an employer conducted a pre-employment background check of some sort, and we'll talk about the 2 ways in which that could occur, and obtained genetic information from either a data aggregation service, or, and we'll talk about that more in a moment, or alternatively by performing its own search. So go online, you have an employee, a potential employee coming in. Before they get there, you run a little search on Google, and let's say some information pops up. If some of that information is genetic information, and again, keeping in mind that it's a very broad definition of what constitutes genetic information, this exception says it's not a violation of GINA. So long as your intent was not to obtain genetic information. Well, in the past, the likelihood that an employer would even be able to obtain materials that could possibly shed light on a potential or current employee's genetic status was quite low. Today, such a risk is far from merely theoretical. Recent studies show that anywhere from approximately 20% to a whopping 91% of employers, I should say, now use social media in one way or another to screen potential job applicants. Consequently, the marketplace has rapidly responded to this demand for comprehensive data about current or prospective employees with new companies, products, and services. And I'll give you one example. There's a company by the name of ISO that provides what they call a web presence search. That it claims, according to the website, makes, quote, it easier to probe the internet for hard-to-find information on persons of interest. They further state that this is purportedly accomplished in part by identifying, quote, an individual's web footprint, the trail of digital information left behind from participation and postings on social networking and other websites. Furthermore, ISO asserts that it then combines this with online search results with public record findings from third-party sources such as data aggregators and government agencies, thereby providing, quote, one of the most effective, innovative ways to compile a comprehensive, multi-dimensional profile of a particular individual. Many of these companies also claim that their products and services are legally defensible and, quote, usable in the hiring process, as the reports redact what they often refer to as protected class and other information not relevant to the position. Even with that claim that a company like this redacts or screens out genetic information in the final report sent to the potential employer, such remaining data that might not be removed could provide a potential employer with substantial clues as to the fact that this individual has either tested positive for some sort of known genetic mutation, or might be at a much higher risk than normal for carrying a genetic mutation due to some sort of family history. So for example, let's say you have data that job candidate A has tested positive for BRCA1. Certainly this is the type of information that you would expect to be removed on one of these reports, at least those entities that claim to redact information that is not, redacts information to ensure that they're legally defensible. But the remaining information still may provide potential employers with some very valuable clues concerning the employee. So for example, if we have the information that this person was BRCA1 positive, that appeared on their Facebook site, and they removed that, the entity providing this report. The fact that candidate A has also, let's say, searched for information on BRCA testing, has liked on their Facebook page an organization such as FORCE. FORCE stands for Facing Our Risk of Cancer Empowered, which is a, quote, nonprofit organization dedicated to improving the lives of individuals affected by hereditary breast and ovarian cancer. So like that Facebook page, and let's say also has run numerous 5Ks to raise money for research on genetic conditions. That may not constitute, under the definition of genetic information under the Act, the sort of information that's prohibited. I would argue that nonetheless it's quite revealing about the possible job candidate. So the solution with regard to this exception would be to amend the current regulation to ensure that an employer who conducts an internet search or orders this sort of report from a third party has to refrain from obtaining not only genetic information, but also data that I have titled genetic status indicators, namely materials that are likely to provide clues or an indication of either an individual genetic status, whether it be current or future, as well as a familial genetic status. So, as previously mentioned, currently the safe harbor provision provides that the exception or the safe harbor from receiving commercially and publicly available commercially and publicly available materials applies so long as the employer didn't set out initially to find genetic information. However, such a mens rea is really unlikely to be present when an employer goes on Google, types in the prospective job applicant's name, or orders a search about this potential employee to be conducted by one of these third-party entities. Consequently, GINA really, to be effective, needs to be changed to ensure that and prevent compromising the statute's protections by removing the intent requirement and instead providing that the commercially and publicly available exception, safe harbor, is not applicable to genetic information or materials that are likely to provide an indication of a potential or current employee's genetic status, whether personal or familial, if obtained through commercially and publicly available sources that are reasonably likely to result in acquisition of such information. So in the cases of situations in which an employer does their own search, this would mean that if they're looking online, they need to stay away from sources of information or websites that seem to really be focused on genetic discrimination, genetic information, and genetic status indicators that might provide information about the candidate's own genetic history or information data, or their families, which would then go to the genetic information definition, the broad definition that is now in place. Moreover, whenever an employer is using a third party, I would recommend that the regulations also be changed to include a requirement that that employer, or prospective employer, needs to affirmatively request that any genetic information or genetic status indicators not be provided to them. These alterations to the commercially and publicly available exception, I would argue, are necessary to really fulfill the goals of GINA that resulted in its passage in the first place. All right, let's move on. Okay. Another exception to GINA's prohibitions on acquiring genetic information are often referred to as the water cooler exception. The general prohibition, the exception, provides that where a covered entity, such as an employer, inadvertently requests or requires genetic information of the individual or family member of the individual, this won't be deemed a violation of the Act. This provision was put in place to deal with the concern that potentially even casual conversations between, let's say, an employee and their supervisor could result in a claim for the acquisition of genetic information. So that just the response to an ordinary question like by the supervisor to an employee, how are you doing, could result in information about the let's say individual's family, health status, such as I'm really upset, my mom was just diagnosed with breast cancer, that sort of thing is something that falls within this particular exception. The new regulations extend this particular exception to social media as well, providing that that an employer is not going to be held legally responsible for a supervisor, for example, inadvertently learning genetic information from a social media platform like Facebook, which he or she was given permission to access by the employee, the creator of the profile at issue, I should say. As such, if an employer and a supervisor, I should say, if a supervisor and an employee are Facebook friends, and the employee posts information online on their Facebook page, let's say their mother being recently diagnosed with breast cancer, and the supervisor sees this, that is not going to constitute a violation under GINA. Now, certainly, to the extent that an employee or potential employee doesn't want an employer to be able to access this information, they have a couple of options. One, don't post it at all. And two, if you do decide to post it, make sure you don't Facebook friend your supervisor. Increasingly, however, the second option is one that might not be sufficient. The possibility that employers or potential employers might seek or even require access to one's private social media sites is far from purely hypothetical. This is because now employers, many expect applicants to divulge their social media passwords or grant access to their profiles as part of a pre-employment screening process for any sites protected with optional privacy controls. And this is an issue that has come up in numerous states. Some of the first examples involved a town in Montana that was requiring any individuals applying for positions within the town to provide this information. And another very notable case involved the Maryland Department of Corrections. There was an employee who had taken a leave, and under the guidelines, when you take a leave, you need to be reinstated through a screening process. And part of that screening process required the employee to grant access to his Facebook page. The ACLU got involved in that particular case, and the Maryland Department of Corrections backed down and changed their employment screening process so they no longer include this. But those aren't just anomalies. There have been reported cases in many other states, including New York, Illinois, Virginia, Michigan, and some states are actually attempting to legislate against this. But it's sporadic and it's not well organized. one thing to keep in mind, in these cases in which employers were getting access to potential employees or current employees' social media sites, they weren't doing it in some sort of surreptitious way. They weren't, cracking the code to the Facebook page to get into it. They were given this information with the employee's knowledge. Now, it was probably provided from the employee or potential employee with some concern or hesitation or both. Nonetheless, an employer could arguably take the position that they did have the necessary consent to allow the employer to fall within the exception as currently written. Consequently, I would argue that the statute really needs to be amended to make clear that this exception can only be utilized by an employer only when an individual has voluntarily provided access to their social media sites in the true sense of the word, or email sites, or whatever it may be. Therefore, to the extent that an employer or potential employer requests access to one's email messaging system, personal email messaging system, or other social networking sites in the context of evaluating that individual for either initial hire, continued employment, or any other employment-related decision. This will not constitute being given permission for purposes of the Act. And again, just like the earlier exception I talked about, the commercially and publicly available materials, it's important that this actual or perceived ambiguity in the statute and regulation be remedied to provide prospective or current employees with the necessary legal assurances that any sort of genetic information or even genetic status indicators will not be obtained or improperly used by an employer. So in conclusion, the overarching issues of tracking consumers' online activities, the ease of identification, and the widespread privacy concerns it raises are progressively receiving much more attention, not only from academics, but also by the White House, the FTC, and legislatures at both the state and federal level. Nonetheless, at least in the short term, a solution to this problem appears highly unlikely. In the meantime, the changes that I have suggested, as well as others that I discuss on my article concerning this statute, would hopefully go a long way in improving and strengthening GINA. In turn, this will hopefully lessen public concern about the potential misuse of genetic information and ultimately fulfill the objectives that led Congress to pass GINA in the first place.
So we have a little time for questions, and there's a microphone.
Thank you. Great, very interesting discussion. I had a quick question. You started off with insurance and employment concerns, and you kind of focused on the employment aspect of it. But I'm wondering, one, if Obamacare, with the exclusion of pre-existing conditions in the community rating standard, does that alleviate your concerns from the health insurance aspect with this? And two, if it has, have you looked at, I would assume that this also could be a significant issue on the life insurance aspect. You know, one thing life insurers seem to like to do, or is they get misrepresentations in the policy, which they would arguably have information, ahead of time, and then of course they can collect the premiums and always deny the claim afterwards if the risk is realized. So I guess I'm just curious, have you looked at it all in the life insurance aspect, and has Obamacare prevented this from being much of an issue in the health insurance realm?
couple of things. First of all, I will confess, I have not looked at it because there is, I will say, there is a document, and I'm just pulling it up because it was one thing that I haven't looked at in great detail because, quite honestly, it's a bit of a mess. And the interim regulations are just that, interim. So I'm assuming a lot of this is going to be worked out as time goes by. I had pulled the National Human Genome Research Institute, which is a division within the U.S. Department of Health and Human Services, which is responsible for Title I, creating regulations. Actually has something on the intersection, the documentation that was put out by the Congressional Research Service report on how these two acts intersect. And it's in the works how to deal with them. But the American, or the Affordable Care Act doesn't completely, at least my understanding, get rid of all of the problems, because when we're talking about a pre-existing condition, it depends on how we define that, because someone could just have, let's say, a known genetic mutation which increases the likelihood that they might get breast cancer, but they might not actually have been diagnosed with breast cancer itself. So it leaves, at least my understanding, some gap there that GINA protects before the onset or diagnosis of a condition. Similarly, there's an interplay between the ADA, the American with Disabilities Act, and GINA, where the ADA kind of takes over once someone has been diagnosed and is suffering from a condition that qualifies as a disability under the ADA because of the onset of the disease. But prior to that time, just having the genetic mutation may not actually be an indication, either in actuality or a perception of a disability, because they haven't actually developed that condition. In terms of Title I, again, the Title I is limited because of the fact that it doesn't apply to long-term health care insurance, life insurance, I believe life insurance, and is really pretty much limited to group health plans. So that's another area in which there still are some major gaps, and you do have the ability to potentially discriminate for those other type of insurance products.
Possible enough students have one.
So this is super interesting, and one thing that comes across is that, you know, you can say, okay, your genetic information, but it's not just like a photo of your genome or something. It spreads out, where there's all these, you know, implications about it based on what you're searching or hints, and you know, it seems like one way to go is to sort of like more regulations, you know, and think about, okay, like, you know, basically we're thinking about employers and their offices and how they Google, and let's create more rules on Google style. And I was just thinking about how hard it would be to actually control how people Google and police how people Google, and I'm wondering if there's other, sort of like, if there's other approaches to the question. So I just want to suggest two and see what you think of it. One of them is not very lawyerly at all, and one of them maybe would be a little more lawyerly. But so, you know, as much as our genetic information might affect whether we get hired in the future, I'm sure people in this room have all posted other things like, you know, total beer bong fail, with like a photo of them, you know, covered in their beer, or like, you know, oh, this shirt totally makes my boobs look huge, you know, with a, you know, you get the angle, and that's all out there too. And when they get Googled, that'll come up, and that maybe is more likely to strike your average employer as a reason to hire or not to hire someone. And so that information, along with genetic information and health information, all that is out there, and we should worry about how employers find it and think about it. So one solution to that is we should just get over it. Everybody's done a beer bong. Everybody looks for the shirt that makes their boobs look big. was the big deal. Like, just as a society, let's get over this crap. And so who cares if someone has a predisposition for breast cancer? They're good for the job. Let's hire them. And God forbid they get sick, we're going to figure it out. That's one way to go. But the other way is to think of it in terms of that like right to be forgotten that they're talking about in Europe now. In the sense of, what if instead of policing the employer and how they Google, we say to Google, look, once in a while people get to Google themselves and they see what comes up, and if they don't like it, they email you and you're responsible to take down those links. Just like on YouTube, you can email YouTube and say, hey, that's copyrighted, I need you to take that down. Like, do it that way. Police the search engines rather than trying to get into the cubicles of all the bosses. And anyway, I was curious what you thought of those two.
Okay, with regard to the first one, just get over it, that someone has a predisposition to breast cancer. I would hope in a perfect world that would be the case, but it's not. At least the evidence doesn't seem to show that. And that's part of the reason why we have other sort of anti-discrimination legislation, that we would hope someone would not think twice about hiring someone based upon their religion or their race or whatever it may be. But unfortunately, it does happen. So I don't know if it's as simple as just saying, get over it, it's what, it's what's out there. The other thing with genetic information that makes it a little more difficult, or at least different, is it's one of those things that is not necessarily visible, so that makes it a little different. I don't think looking at me you could tell whether I had the BRCA mutation, one of the BRCA mutations or not. I don't, but so that makes it also a little difficult. So there's, in some ways you can say, well then there's less to get over because you don't even know it. But it's still an immutable characteristic, and if you do have this genetic makeup, and who knows what it's going to look like in the future in terms of being able to obtain this information. At least for now, there's a concern that, in my opinion, is great enough that this legislation is important and plays a role in society and ensuring that people are not discriminated on that basis. Concerning the right to be forgotten and trying to instead look at this from being able to get an entity like Google to take some steps, it's not that it's not out there, that possibility. As I'm sure you can kind of guess, entities like Google, not really happy about this because their money, a lot of it, is made by getting this information and passing it on to others. And so there is a huge market for that. And there have been multiple pieces of legislation that have been discussed, even introduced in Congress, the sort of do not track initiative, so that entities like Google can't even track you. The do not track legislation actually has a lot of problems, but this concept of trying to give consumers at least some ability to say, I don't want that, I don't want you to be doing it, it's not something that has received much support in the business community.
So I kind of want to follow up on what you were saying just now about the comparison with other kinds of discrimination, which seems like one of the really interesting and difficult things about this. So we know that with, for example, sex or race discrimination in employment, it's very hard to prove, right, as you mentioned. Most of it is not conscious bias. Rarely do employers say these days, we can't hire her because she's a woman. But we know, like many, many studies show that if you have a man's name on your resume, you do better. If your name is Joe Smith instead of Jose, you do better in employment. So much of the discrimination is unconscious. And I'm wondering with genetic discrimination, what level is it operating in the employer's mind? I mean, are these employers saying, sort of consciously on some level, like, oh, that person has this genetic problem, maybe they'll be out of work a lot, or is it much more of an unconscious thing, which would make it more difficult to, you know, prove? And then, yeah, I guess there are just a lot of interesting comparisons.
I think it's a combination of both. I think there probably are some employers that if they find out, just like, if you're a woman of a certain age, you might be out of work to have a baby or something like that. I think there are also employers that say, I have two good candidates here, and one of them I know has a very high chance of developing breast cancer because they have one of these known genetic mutations. Between the two, I'm going to take the one that doesn't seem to have those risks because I don't want to have to deal with someone being sick and out of work or potentially never coming back and investing the time to train them, and it won't work out. So I think there's that aspect to it as well. Your other follow-up question to that was?
I was just really curious in just the comparisons.
Yeah, the comparisons, there haven't, I know what I was going to say. In terms of actual cases that have occurred, a lot of times this will involve sometimes employers who at least seemingly aren't proceeding with trying to obtain genetic information for a bad reason. But, for example, a lot of the cases that have come up, and there have only been 2 cases filed and settled by the EEOC to date. Both involved situations where employers were testing for carpal tunnel syndrome. Now, you could argue that part of the reason why they were testing for this was to be able to identify those individuals, those potential or current employees that might need some accommodations, some sort of special equipment that could prevent problems associated with carpal tunnel syndrome. On the other hand, you could say, well, they're trying to identify those individuals who have carpal tunnel syndrome or have a propensity, I should say, for carpal tunnel syndrome because it's going to impact their employment. So it may not be consciously negative, but it might be. And so one of the ways in which, as I mentioned, that GINA is very unique is it tries to kind of, I think it was Senator Collins, actually, who was one of the big proponents of this legislation to some extent, said this is the kind of thing we just want to take the information off the table because it's possible that this could be used in a way that is improper. And so unlike those other anti-discrimination statutes that deal with protections on characteristics that are much more visible potentially, genetic information has a different quality about it. And so we don't even want employers or group health insurance companies to even have that information to begin with because there is a risk that it could be used improperly.
Okay, well, thank you so much.
Thank you.